Hi there. Um, Amy, do you want to introduce yourself first, or should we wait until you do your thing?
Well, I'll just say a quick hi, and I will give a longer introduction when I start my part of the presentation. Thanks, Tony.
Okay, sure. So I'm Tony Schoenberg. I'm a partner at Farella Braun and Martel. I'm the head of what's called our business litigation practice area. And a lot of my practice involves real estate related disputes and litigation, including a lot of landlord-tenant work, which seems to be busier this year than in most years. And if you could go to the next slide, please. So I'm going to cover basically three things in this presentation, and this all relates to the world we've all been living in for the past 6 or so months. It all relates to issues that are particular to this COVID-19 time period. So the first topic will cover the various federal, state, and local eviction moratoriums that have been implemented throughout the last 6 or so months, and that'll actually be the bulk of the presentation. There'll be a short discussion of some litigation that has been filed challenging some of the moratoriums, and then third, there will be a discussion of tenant bankruptcies and what that means for eviction proceedings. Without any further ado, I will start on the first topic. Next slide, please. So I'm going to start with federal eviction moratoriums. As you may have heard, let me actually start by saying a number of you here, I think, may have more of an interest in commercial landlord-tenant issues than residential, although I think some of you have an interest in residential and some in both. So I am going to be covering both. Most of the federal moratoriums, however, and state for that matter, have been only directed at residential. So the real action in commercial is in the local moratoriums, which we'll get to in a few minutes. The first federal moratorium, though, was in the CARES Act, which you probably recall was the big relief act that was enacted in April. And among a number of other things, the CARES Act implemented a 120-day eviction moratorium on certain rental properties financed through certain federal programs. And that was a residential moratorium. That moratorium expired on July 25th, and landlords could then give 30 days notice of their intention to commence eviction proceedings, and that date, of course, is now come and gone. So the CARES Act moratorium is no longer with us. Next slide, please. About 2 weeks ago, however, the Center for Disease Control unexpectedly rolled out a pretty broad and sweeping eviction moratorium. It got a lot of publicity and it's been written about a lot. It is, again, it's a residential only moratorium, and it halts evictions from September 4th through the end of the year for tenants who meet these certain requirements that include income caps and demonstrating that they've sought governmental assistance, and then they have to make a couple of affirmative declarations about COVID hardships and so forth. Next slide, please. So the one thing about the CDC's moratorium is that it only applies in states and localities that do not provide, I should say it does not apply in states and localities that provide the same or better level of protection through their own rules. And as a result of that, it very likely does not apply in California. Instead, in California, we've had some additional other moratoriums that apply on a statewide level. And of course, as I'll get to in a minute, many of our counties and cities have enacted their own moratoriums. Next, please. So at the state level, you may have heard early on in the COVID experience, the Judicial Council of California imposed a moratorium on all evictions in California state courts. And that was a very sweeping moratorium. It basically said there can be no unlawful detainer actions in any California state courts during the pendency of this moratorium. About a month or so ago, the Chief Justice of the California Supreme Court, who's the head of the Judicial Council, announced that it would be expiring on September 1st. And for those of you who don't know, the Judicial Council is basically the governing body of the California court system. But in that announcement, the Chief Justice said that, basically said that eviction moratoriums really are more in the nature of legislative activity than judicial activity. And so as a result, they were turning this over to the legislature to try to do something. Governor Newsom has pretty early on also enacted an executive order that addressed eviction moratoriums. Basically, what his order did is it effectively said state law will not preempt local eviction moratoriums. So he suspended state law limitations on local jurisdictions so that they can impose their own moratoriums. And that has been extended a few times, and that goes through September 30th. But most recently and most significantly, next slide, please. About 2 weeks ago, the California legislature passed Assembly Bill 3088, and it was signed by Governor Newsom. And this is the California legislature's first shot at dealing with these issues of evictions and COVID and you know what to do about that. So Assembly Bill 3088, I guess I would preface this by saying it was the result of quite a bit of legislative wrangling. It had been preceded by an earlier Assembly bill that was viewed as being very, very pro-tenant and had a lot of resistance from landlords and property owners. And then during the last week or so, there was sort of a furious amount of legislative activity and I think a lot of late night sessions that resulted in what is generally viewed as more of a compromise bill between those two interests. So 3088, it applies only to residential tenancies, not to commercial. And the specific things that it does include, it requires now that landlords give a 15-day rather than a 3-day notice to quit in order to evict someone. Furthermore, it provides that for any rent missed between March 1 and August 31, that cannot form the basis for an eviction so long as the tenant returns a declaration of COVID-19 related hardship within that 15-day notice period. And if the tenant does that, then the missed rent, it's converted to civil debt, basically. It's not rent forgiveness. It simply means the landlord in that case can only recover rent through basically a small claims court action. They cannot evict the tenant for not paying rent. And then for tenants who fail to return the hardship declaration, evictions can begin starting on October 5th. Next slide, please. 3088 further provides that for rent missed between September 1st and January 31st, that cannot form the basis for an eviction if the tenant, A, returns the COVID-19 related hardship declaration within that 15-day notice period and pays 25% of the rent by January 31, 2021. And to be clear, that means that during that time period, September 1st through January 31st, theoretically, a tenant could pay $0 in rent in September, October, November, December, and January, and then on January 31st, pay 5 months rent. I should say 25% of 5 months rent, so 125% of a month's rent, and would satisfy these requirements and could not be evicted for not paying the other 75% those 5 months. And if a tenant satisfies those rules, then the remaining 75% of the rent is treated as civil debt. So it's not forgiven, but it cannot form the basis for an eviction proceeding. And then eviction for just causes other than non-payment, such as causing a nuisance, can begin effective September 2nd. So that has already started, obviously. Next slide, please. Furthermore, existing local moratoriums do get grandfathered in until their expiration. No new moratoriums or extensions, however, at the local level can take effect until February 1st, 2021. And it is very much expected and contemplated that, well, I should say, 3088 by its terms expires on February 1st. And it is very much expected and contemplated that there will be further legislation to follow 3088. And in fact, David Chu, who was one of the main architects of 3088, has already been talking publicly about the next bill. So, so stay tuned for that in sometime probably in early 2021. Next slide, please. So I'm going to talk now about some of the local moratoriums that have been enacted, just so you can get a flavor for what they are look like and what their requirements are and where they do and don't apply. And for most of these, I'm going to talk about both the commercial moratoriums for commercial tenancies as well as residential moratoriums. So San Francisco enacted a moratorium. There's a commercial component to it, which covers commercial tenants and subtenants who are registered to do business in the city and who have gross receipts of 25 million or less in 2019. And this includes nonprofits that meet that gross receipts threshold, or ceiling, I should say. If a tenant satisfies those requirements, and that tenant then misses a rent payment between March 17th and September 30th, or missed one, the landlord must then give the tenant notice at least 1 month, and at least 1 month to cure before the landlord can recover possession. And then if the tenant can provide documentation of inability to pay due to COVID-related financial impact, the tenant can then extend that cure period by a month, and there's a maximum of 6 months that can be extended. And this last bullet point says maybe extended again because I expect that there will be a further extension and maybe some additional rules passed in San Francisco. Mayor Breed has actually just about a week or two ago extended this commercial moratorium's deadline from, I believe it was September 14th to September 30th. And her public statements surrounding that made it sound like there's probably more to come on the commercial front. So stay tuned for that also. This is an ever evolving ecosystem of state, local, and federal legislation. Next slide, please. So as far as residential tenancies in San Francisco's moratorium provides that tenants who are unable or were unable to pay rent due to COVID-19 between March 13th, which was the date this was enacted, and the expiration of the moratorium order cannot be evicted until 6 months after the order expires. And the order currently expires at the end of this month, which means that there can be no evictions until April 1st, 2021 under this moratorium. Next slide, please. Oakland also has a moratorium. The commercial component of Oakland's has a slightly different definition of who's covered by it than San Francisco. Oakland covers small businesses as defined under California Government Code Section 14837D, which provides that a small business is one that has fewer than 100 employees, average annual gross receipts of 15 million or less, and a principal office located in California, and it does cover nonprofits. Covered entities, that is tenants who are covered by this, cannot be evicted for failing to pay rent if non-payment was caused by a substantial decrease in income caused by COVID-19. And that terminology, substantial decrease in income, is not defined in the legislation, so it's unclear exactly what that means and how big of a decrease is required before you can qualify. So that currently is effective through September 30th. So the expiration on that is fairly soon. Next slide, please. Oakland's residential moratorium is one of the most sweeping and tenant protective of all of the moratoriums that I'm aware of. It prevents evictions of nearly all residential tenants during the pendency of the local emergency declared by the city of Oakland. And no one knows when that local emergency will be deemed over. So right now it's of unlimited duration. And it also prohibits evictions for most reasons, not solely for non-payment of rent. And that makes it somewhat unique among these moratoriums. Many, if not most of them, only apply to eviction for non-payment of rent. Next slide, please. Contra Costa also has a moratorium, and the Contra Costa moratorium treats commercial and residential basically together. It does cover small businesses similar to Oakland. It uses the same government code definition as Oakland. So those tenants who meet that definition are covered by this, commercial tenants. It also covers nonprofits. And it provides for commercial and residential that tenants cannot be evicted for failure to pay rent if they provide notice and documentation that they lost a job, income, or have increased medical expenses due to COVID-19. And this currently goes through September 30th, 2020, although for residential, remember that there's now a state law that provides a moratorium for residential tenants that will go beyond that. So next slide, please. So there have been a number of other moratoriums in Northern California, and these are just a few examples. This is not meant to be exhaustive or comprehensive, and I'm not going to go through the elements of each of these, but just so you know, Alameda County Superior Court, the court imposed a moratorium that expires at the end of the year, and as I believe it is a moratorium not on eviction proceedings, but on the execution of writs of possession. So as I understand it, unlawful detainer cases can happen, but they essentially, possession cannot be recovered until after the end of the year. Santa Clara County also has a moratorium. It expires at the end of this month. San Mateo County had a moratorium that expired at the end of last month. But of course, for all of these, when it comes to residential tenancies, California's Assembly Bill 3088 applies. Next slide, please. So there has been litigation challenging some of these different moratoriums at different levels of government. So I'm just going to quickly talk about some of the challenges and what resulted from those challenges. So first off, in June, a group of real estate trade organizations sued in San Francisco Superior Court to challenge the San Francisco moratorium, primarily on the ground that it's preempted by California law. And next bullet, please. So that lawsuit was defeated in an order dated August 3rd of 2020. The court rejected the challenge. The court found that the moratorium was a proper exercise of the city's police power, among other things. And so that was a victory for the city of San Francisco and the city attorney's office who defended that case. Not a surprising result, but just interesting to be aware of. Next slide, please. So there were several lawsuits filed in the summer, not in the Bay Area, but mostly in Central California, that challenged the Judicial Council's eviction moratorium, primarily arguing that it violated the separation of powers because, according to the plaintiffs in these cases, the judiciary was basically legislating. And next bullet, please. Those cases, of course, are moot, given that the Judicial Council allowed the eviction moratorium to expire. And interestingly, the Chief Justice's comments in announcing publicly that they would allow this moratorium to expire basically agreed essentially with the plaintiffs in those lawsuits, in that the Chief Justice said that really this was more in the nature of a legislative responsibility than a judicial responsibility. So, next slide, please. So on the federal level, last week, a landlord in Virginia filed a lawsuit in Georgia, where the CDC is headquartered. It challenges the CDC's moratorium on grounds that it exceeds constitutional limits on federal power. And according to commentary, other similar lawsuits are likely. Next slide, please. So I'm going to talk for just a moment about tenant bankruptcies. There, not surprisingly, tenant bankruptcies are up, and I'm certain that we'll see a lot more of them. And there are some very specific things that happen when a tenant files for bankruptcy that are worth knowing about. And I will preface this by saying I am not a bankruptcy attorney. A lot of this information I got from one of my partners who is a bankruptcy lawyer, but some of these concepts I'm familiar with through having practiced law for 20 years. So, but this has all been verified and approved with the seal of approval from my bankruptcy partner. So, so let me just talk about the basics. As you may know, when an entity files for bankruptcy, something called an automatic stay immediately kicks in the second that bankruptcy petition is filed. And the automatic stay prevents all actions against the debtor or the debtor's property. And as a result, a landlord cannot thereafter enforce its rights under a lease, including demanding the payment of any pre-bankruptcy petition rent, or trying to pursue an unlawful detainer action to get a tenant out. And nonprofits can file for bankruptcy if you were not aware of that. Next, please. So there are some of the basics include the following. Once the bankruptcy petition is filed, a tenant has 120 days, which can be extended for up to 90 days, to decide whether to assume and assign or reject its lease. And you may know this if you know a little about bankruptcy, that it's normal in bankruptcy proceedings that the debtor will have the opportunity to either assume and assign or reject all of its executory contracts. And so leases are simply a part of that process. So in the event that the debtor rejects the lease, the debtor is required to continue to pay post-filing rent, that is rent that accrues after the filing of the bankruptcy petition, as well as any other obligations under the lease, starting on the date of the filing of that petition until the rejection of the lease. And as the parenthetical notes, the bankruptcy court can sometimes permit deferral of those payments until 60 days later. But the debtor is not required to pay rent and obligations that accrue prior to the bankruptcy. Next slide, please. If the debtor rejects a lease, it is deemed a breach, and that allows the landlord to terminate the lease and retake possession of the premises. And if the landlord does that, the landlord can then assert a claim for damages resulting from the lease rejection, and that gets asserted against the bankruptcy estate. And the calculation of damages is calculated initially under state law, but it is subject to a cap under the bankruptcy code. Next, please. On the other hand, if the debtor assumes a lease, it is required to then cure all lease defaults, with some narrow exceptions for non-monetary defaults. And that includes paying any delinquent rent and any other obligations, both pre-filing of the bankruptcy petition and post-filing of the bankruptcy petition. The debtor must also provide adequate assurance of future performance under the lease. And once the lease is assumed, any ongoing obligations have to be timely paid, with any unpaid amounts being treated as administrative expenses of the bankruptcy estate. They generally have to be paid in full in order for the debtor to exit out of bankruptcy. Next, please. And the last point on this, I mentioned this actually came up in something I'm working on just a few weeks ago. If prior to a tenant filing for bankruptcy, a landlord settles a lease dispute with the tenant in which the tenant makes a monetary payment to the landlord, and the tenant then files for bankruptcy within 90 days of that payment, it's very, very possible, if not likely, that the payment would be clawed back from the landlord in the bankruptcy matter as a preference. A preference is basically payments that are made within 90 days of a bankruptcy filing are often regarded as preferences. I think there's a presumption, in fact, that they are. So just something to be aware of. I am now going to turn it over to my partner, Amy Briggs, who is going to talk about some insurance matters.
Good afternoon, everyone. My name is Amy Briggs. I'm a partner in the Insurance Recovery Practice Group. Right from the outset, I want to make clear that my preference is really to address the issues, the insurance issues that are on your mind. I put this presentation together based on kind of my best estimate of what might be of interest to this audience, but it should in no way preclude you from asking questions, even if you are concerned they might be off topic. Do not worry about interrupting me. I hopefully will be able to see your questions through the chat box, and I'm happy to respond on the fly. And if there's a more complicated question, I might just bump it to the end. But just to reiterate, this presentation is for you, not for me. I listen to myself talk all day, as my family will tell you, unfortunately, all too readily. So the way that I structured this presentation is I wanted to give the audience an overview of the current litigation environment in which we find ourselves in. As Tony already alluded to, litigation is up, and bankruptcies are up. It is a legal, it's a legal mess out there. So the focus of this presentation is going to be on the business interruption coverage litigation arising out of COVID-19 specifically, but that it does not necessarily, that does not mean that that's the only thing we have to talk about. So feel free, as I mentioned, to ask other questions. Margaret, I see that my old outline is in here, so let's just move on to the first section. This is data that is taken from a company that does data analytics on a number of legal issues, including case filings. What you can see here is that, within the first 6 weeks following the shutdown, there was a significant uptick in complaints citing COVID-19. Next slide. And when you look at what those complaints consist of, you can see there are two main spikes. Neither of which is probably surprising to the audience. The first is in the contract area, and the second is in the insurance arena. Of course, insurance is a contract dispute, but we'll put that aside for a moment. Again, this was a snapshot taken early on in the pandemic, but I suspect more current data would show that these trends have continued. And certainly we know that lots and lots of insurance cases have been filed in the months following the shutdown. And as I'm going to talk to you about in just a minute, we are starting to get the results of those cases in as courts begin handing down decisions. Next. So as you saw earlier, there was the contracts and insurance categories that formed kind of the biggest part of the spike in litigation. And I'm not going to be talking about the contracts litigation per se, but did just want to quickly mention what they largely consist of, and that is consumer class actions, basically consumers who had purchased airline tickets, hotel reservations, services, goods that for a while following the pandemic, businesses were trying to give consumers credits for future goods or services, and consumers weren't having any of that. They wanted their money back, understandably. So a lot of the class actions evolve around that, also including universities. Who have been sued because they did not refund tuitions. The other part of the contract litigation revolves around impossibility and force majeure. I'm sure most of this audience has taken a look at contracts relating to their organizations to see what the force majeure clause says. You will not be surprised to hear that the meaning of the force majeure became the focus of litigation very quickly. And then the second spike was litigation. And this has been largely driven by litigation, what has been referred to as business interruption litigation. Business interruption is a type of coverage that you can buy for when events impact your business operations. And that is what policyholders are suing over. And further, as we'll discuss, has been the subject of a number of proposed legislation over the last 6 months. And I'm going to give you a brief over that as well toward the end of this presentation. Next. Before I get into kind of how the litigation has been going for policyholders, I wanted to orient everybody towards the coverage issues that have surfaced, so that you have an understanding of what is really being fought over. It's important that I caveat to any policyholder that business interruption coverage is a little different from other types of insurance in that it is highly, highly individualized. There certainly are some types of standardized form coverage for business interruption, but particularly for larger policyholders, a lot of it is individually worded. It is absolutely critical that a policyholder read their particular insurance policy and not draw generalized conclusions based on what I'm about to say. Small differences in wording can make a big difference in terms of coverage, and we're gonna get into that. One of the standard phrases that has very much been the subject of litigation is that business interruption coverage, as well as some of the other coverages that are often sold with that, civil authority coverage being another example, cover direct physical loss of or damage to property. And that phrase in particular has become really the hot button of litigation. What does that mean? Is the loss of use of your property without any physical damage enough to satisfy this coverage? When you look at kind of the plain meaning, direct physical loss of or damage to property, you might think, well, sure, this covers direct physical loss of property, and I lost the use of my property. Courts do not see it that way, or they haven't so far, and I'll explain a little bit more about that in connection with the next slide. Then if the court reaches the conclusion that some kind of physical damage, as opposed to just the pure physical loss of property, is required, the next question really becomes, well, is the presence of the virus enough to cause a physical loss of or damage to property so as to satisfy this? And does civil authority coverage or contingent business interruption coverage, which might also be additional coverages that you might have purchased, also require physical damage to property? And whose property might be damaged? You might not have had the virus on your property, but if the virus was on a nearby property, could that somehow trigger coverage? And then finally, and I don't want to overlook the importance of this, is there a virus exclusion in your policy? Virus exclusions have been written in lots of different ways. A lot of them are pretty clear in my view. Virus is a virus, and if the insurance company has been saying that they don't cover any loss arising out of a virus, I think it's going to be hard as a policyholder to get around that. These virus exclusions, were they were introduced into insurance policies quite a while ago, following the SARS epidemic. I think they really came into fashion around 2006. So they've been around for quite some time. It's just now in our current environment that they've received a lot of attention. Next. So we're going to talk about, as I said, we're going to talk about the litigation and how it's going overall for policyholders. And I'm going to begin by talking about generally, at a general level, the thousands of individual lawsuits that have been filed against insurance companies, largely by small businesses, hairdressers, restaurants, gyms, all those, smaller businesses that have been so impacted by the shutdown. These cases, these plaintiffs have essentially pursued two theories of liability, one of which seems to be succeeding better than the other. But I do want to caveat my overview by saying that it is still very, very early in this litigation. There will be a lot more decisions coming down, and the decisions that have been coming down, many of them will go up on appeal. So this will be a constantly evolving landscape over the next several years. So the first theory of liability against the insurance company is that policyholders have argued that the civil orders shutting down everybody's business themselves cause the direct physical loss of the property. That's argument number one. Argument number two is that certain businesses actually had the virus on their premises. Maybe an employee was infected, maybe a guest, a tenant was infected, and that event in and of itself, the presence of virus, caused the loss of use. And as I made a note there that one case which adopted this theory has become kind of famous in coverage circles. I understand that is a very dubious distinction in the Western District of Missouri in federal court, because this is one of the few policyholders that has survived an early motion to dismiss by the insurance company. They alleged, I think it was a conglomerate of restaurants or salons, they essentially alleged that the virus had attached itself to their property, that it had been brought onto the premises, that it was attached to their property, causing physical damage. And the court said, hey, at the motion to dismiss stage, which is a very, very early stage in legal proceedings, that's enough. You don't get thrown out of court right now. It's not a ruling on the merits. It just says you get to move past the initial complaint stage. But overall, this, as I've alluded to, the litigation isn't going so well for policyholders so far. And I'm going to give you a couple examples next. I focused on California because I think it really highlights the different ways that courts are viewing the key language that I highlighted, this direct physical loss of or damage to property. There have been lots of different issues brought up in the early briefing in these cases, but the one that I'm going to focus on just for the next couple minutes is this issue about whether civil shutdown orders cause direct physical loss. The first decision came down about 3 weeks ago, was brought by Inns by the Sea, and it was a California state court decision. And then much more recently, in the last week or so, there have been two decisions out of federal courts in California. Let me just pause by saying that California is one of the more policyholder friendly jurisdictions. So I think that, everybody needs to pause and think about, well, if this is how California is treating the issue, I'm not sure there are a whole lot of other jurisdictions out there that are going to be kind of better for policyholders. And that's not great news. So the decision that came out just a couple weeks ago was this 10E decision. 10E is a restaurant in downtown Los Angeles, and it brought suit against Travelers. And again, the phrase in the policy was that the policy covers direct physical loss of or damage to property. And 10E argued that was satisfied by the civil shutdown order. The restaurant could not open. They lost the use of those premises, and this should be covered. And the district court rejected that theory completely, threw the case out of court at a very early stage in litigation, and said that no, what that phrase really means is that the policyholder must show a distinct, demonstrable physical alteration to the property. So a civil shutdown order does not cause a physical alteration to the policyholder's property, right? It prevents you maybe from utilizing it in the way that you intended, but it does not physically alter the property in any way. Last week, there was a decision out of the Southern District of California where the same language was at issue, this time in a policy issued by Farmers Group, and the court again threw the whole lawsuit out, citing the 10E decision. Just a brief note, if I could look into my crystal ball, and I hope I'm wrong, I don't have a degree in fortune telling, but what I think we're gonna see is kind of a snowball effect here. I think these decisions will begin to build on each other. Courts who are confronting these relatively novel issues that have huge, huge consequences for policyholders across the country, they are going to take refuge in the fact that courts before them who have confronted the same issue are reaching the same conclusion. And the more sites that they can fill into their decisions, I think the better that it's going to make the courts feel about ruling against the policyholder. So my prediction, unfortunately, is that these will really start to accumulate and rack up in favor of the insurers. And certainly if you look at the headlines, the insurers are already touting that they are winning this battle. Next. Another type of litigation that has been brought has been a class actions against, or putative class actions, I should say, brought against particular insurance companies that might have issued the same type of form to multiple different policyholders. So in this case that also just came out a week ago in the Northern District of California, this was Mud Pie, which some of you may know. It is a clothing shop in San Francisco, sued Travelers, alleging that same theory of liability, which is that the civil shutdown order satisfied the direct physical loss of property that the policy covered. And the court disagreed and has thrown the suit out, although it's given Mud Pie leave to amend, but basically has expressed kind of grave skepticism that Mud Pie is going to be able to adequately amend the complaint. But what was interesting to me about this court's decision is that it directly disagreed with the prior two decisions, saying, look, direct physical loss of property does not in fact mean that you have to have a physical alteration to that property. That's not what that phrase means. However, loss of, the court concluded, really refers to a permanent dispossession of your property. So for example, cargo that, this is actually one of the cases, cargo that gets lost in China and was never recovered. That was the type of permanent dispossession without any showing of direct physical loss or physical alteration to the property that satisfied the requirement. So class actions, and I raised class actions, and we'll get to this in just a sec, because as a policyholder, your organization may already be part of a class and you just don't know it yet. Then also policyholders have tried to bring multi-district litigation against the insurers. I'm not going to spend a ton of time on that, but it has not so far been particularly successful, in large part because the courts, looking at the issues presented in these cases, have found them to be incredibly varied. As I mentioned, different policy language, different state law applies, different circumstances of the policyholder, different circumstances under which the policy was purchased. So all of those factors led the judicial body that is in charge of multi-district litigation to essentially conclude that multi-district litigation, it was just too disparate and it was not a good idea. So far that has not succeeded. The last piece of the litigation landscape that I think is interesting, but maybe not as good as I had originally hoped, is that it comes out of the UK. The UK is regulated by the Financial Conduct Authority, and the FCA brought a case against a group of 8 insurers, and it did so with these insurers' permission. And it brought the case in June. It got it to trial in July, and we now have a ruling on that. The court examined these different insurers' language, different types of coverage, and concluded, and this is a decision that I think arguably has binding effect on the entire insurance industry in the UK, that in fact these policies largely provided coverage for these policyholders. So at least for the UK, a lot of these smaller, the pubs, the restaurants, the whole thing, that this decision is extremely good news. Last week, before I knew the details of the decision, I had been wondering whether or not there would be any overflow effect if the decision went in the policyholders' favor. Would that be helpful to policyholders here in the US? I won't say I reviewed the entire decision, it's 160 pages, but I reviewed significant parts of it. And what I tentatively conclude is that the coverages that are being written over in the UK, even though they are written by the same insurers who are issuing policies here, the coverages are different. And so I don't believe that the court in the FCA trial ever addressed what seems to be the really critical issue of direct physical loss of or damage to property, because that's not how those policies read. So my hopes for kind of an overflow effect in favor of policyholders are dimming, although I haven't completely concluded that analysis. Next. Briefly, I want to touch on the regulatory side of things and kind of, what's happening both amongst various legislators, as well as regulators. So very quickly, as most of you probably know, the California Department of Insurance reacted quickly to the shutdown, ordered insurers to provide initial premium refunds. I hope you all have gotten at least, some part of your refund. I know I got a very small one. I thought I deserved a much larger one, but in any event, that happened. And then the CDI followed up in June by ordering insurers to recompute workers' compensation premiums. That could be quite significant. Workers' comp in California is extremely expensive. And the risk that is being insured under those policies simply is not occurring, because we are all sitting in our homes, not commuting to work, not going about the normal workday activities that give rise to workers' compensation types of risks. Okay, so turning to the California legislature, I wanted to call your attention to a bill, SB 1159, which has created a rebuttable presumption for workers who contract COVID-19, whether they are injured or actually die from it. In the workers' compensation context, the presumption is, and again, it's rebuttable, but the presumption is that if you have an employee who contracts COVID-19, the presumption is going to be that they got it while working, assuming that they are working in the, at the place of work and not just in their home. This is a presumption that will be in effect until January 1st, 2023, and that presumption really shifts the burden to the employer to disprove it. I can think of, I'm not aware of any cases so far, but I can think of a number of ways in which you might, an employer might rebut that presumption. For example, are you dealing with a 25-year-old employee who has continued to lead a very active social life, notwithstanding the shutdown orders? Are there pictures all over their social media accounts of them, raising a drink and hanging out with buddies? That might be the type of evidence that employers start turning to rebut that presumption. Finally, I wanted to briefly mention AB 1552 because I thought it was a valiant effort to get a pro-policyholder Bill passed, it did not pass. So this is a moot point as of right now, but it basically, in certain circumstances with certain insurance business interruption policies, it would have created a rebuttable presumption essentially in favor of coverage. As long as you didn't have that virus exclusion in your policy, it would have really, I think, tilted the seesaw in the policyholder's favor. It did not pass. And one quick note about that, you know, this didn't rewrite anybody's contract. This didn't do any of the more drastic things that other states are trying to do, and it didn't get passed in California. So I think that says something probably not very good for those of us on the policyholder side. Next. Other state legislators have introduced a number of bills to try to help policyholders out. I'm not going to go into detail. They all essentially work the same way. And that is the proposed legislation would require insurers to cover COVID-19 business interruption losses. And that is regardless of what the policy says, as long as it's business interruption coverage, regardless of whether there's a virus exclusion in the policy, these bills tell the insurance industry to cover the loss. And the backup, there is a state-backed fund essentially that the insurers would then, after having paid out the losses, would then recover from. Those types of bills have been proposed at both the state and federal level. I've been reading the commentary on them. I don't think anybody out there is giving them a very significant chance of ever coming to fruition. These bills, even if they were passed, I think, would run headlong into a contracts clause challenge from the insurance industry and would be litigated for many years. If anybody had any doubt about that, Chubb's CEO recently took to the airwaves, and I've included just one of the things that he said in response to this idea that there could be a mandatory coverage law coming from either the state or federal government. I don't think that, I think it's a low likelihood that it will happen in the first instance, and then my crystal ball prediction, it's going to be tied up in litigation for a long time. So I don't think we can necessarily count on help from that branch of government. Next. So if you're a policyholder and you've just heard this, very depressing presentation that I've made to you, and I'm so sorry, it's Thursday afternoon and I know it's getting late. You may be thinking, well, what do I do? Should I just, burn the policy, forget about it, walk away? First and foremost, I wanted to call a feature of these policies to your attention and make sure that everybody in the audience is aware of something that makes their business interruption coverage unique. And that is that it very likely has a contractual statute of limitations buried in the lengthy pre-printed form. And that contractual statute of limitations gives a policyholder 1 year from the date of loss to file suit. And if you do not have a lawsuit against your insurance company on file within that 1 year period, you are barred from coverage altogether under most states' laws. Again, it's state specific. So the first thing that I tell policyholders is, even if you think the news is, beyond hope, even if you have no intent of pursuing a claim right now, just make sure that you have your eye on that statute of limitations, which means read your policy, know what it is, and put in your calendar when that limitation period is going to run. Because we don't know what's going to happen between now and then. And you may be in a position where you're asked, do we have a claim under the policy? And the answer that none of you are going to give, having heard this presentation, is, well, we might have had a claim, but now it's time barred. Okay, don't be that person. So know what your policy requires in terms of filing suit, because it's different from state law. Okay, if you ask somebody, if you ask an attorney who doesn't do insurance coverage, what's my statute of limitations on a contract claim, they're going to tell you 4 years, and they're going to be right. But what they may not know is that these policies are a little different. And in bad faith, by the way, is a 2-year statute of limitations. So if you can meet your 1-year statute of limitations, get a tolling agreement in place, whatever you decide you need to do, you are going to be in a much better position to make an informed decision. That also means putting your insurer on notice of a loss if you haven't already, and making sure you're aware of some of the other internal timing requirements that doing so triggers. For example, policyholders must submit something called a proof of loss. Oftentimes, they have a limited amount of time to do it. That's easily dealt with. Get an extension in writing with your insurance company if you need to do that in order to preserve your rights. Next. Here are some other things that I might be thinking about in addition to when the statute runs. I would want to make sure I know what my particular policy says. Does it have unique wording? Can a particular policyholder allege physical damage in a way that will satisfy some of the rulings that are coming out of these courts? For instance, was the virus at your particular property? And finally, and most importantly, I really would want to know if your property policy, if your business interruption coverage has a virus exclusion. And if it does, how clear is it? Because that, at the end of the day, I think is what a lot of this litigation will come down to. I think I would also want to know whether or not I'm already a part of a class action. How's it going? Who's representing me? Because as I mentioned, some of these forms were standardized and some of these insurers have been sued. And then finally, I think I'd want to consider how large my loss is. Is it worth pursuing a claim? Maybe a class action makes a lot of sense. Those are typically on contingency, and they're designed for situations where it might not make sense financially for a policyholder to pursue a claim all on their own. Next. So in sum, the takeaways, I think, for where we are right here today is that I wouldn't hold my breath for a legislative solution to the insurance coverage problems. As I mentioned, I think the judicial decisions that are coming out negatively to policyholders may have a snowball effect, and we may just see the insurance companies really running away with these very early motions to dismiss. Read your policy as a policyholder, be informed, know what your legal options are, know what the timing of your legal options is going to be. Make sure you're perfecting your rights and stay informed of any legal developments. Thank you.